happy and another part heard.
Good morning, Mr. Silverstone.
Good morning, my lady, my lords. I have a short handout, if the court would permit. I'd be very grateful if this could be passed up. It's a table which sets out the personal injury exception to immunity as contained in both the conventions and in various domestic legislation.
Thank you very much.
All of the authorities are in the bundle.
Thank you very much. Professor, you've got a copy of this.
Yes, I have. Thank
Good. Yes.
My lady, my lords, I was dealing with authority on the interpretation of the 1978 Act and the conventions. If I can ask the court to turn now to a very short passage from the Privy Council decision in La Générale des Carrières, which is in Bundle 5, tab 67, page 1598 or 505 of the electronic bundle.
Page?
It's page 505 of the PDF, page 1598 of the hard copy pagination. Paragraph 10.
I'm afraid my bundles have been split up in an odd way electronically, so I'm struggling. What tab number is it?
It's tab 67.
67.
Lady.
I have it. Thank you very much.
One
and then
number.
paragraph 10.
Paragraph
Sorry,
10.
one
Volume number 5.
Yes.
And it's the final sentence of that paragraph. The State Immunity Act was aimed at giving broad effect to, though not following precisely the wording of, XC, which was agreed under the aegis of the Council of Europe.
Yes.
And we'll return to that theme as my submissions continue. The next authority, my lady, is Ben Carbuche.
Right, I'm sorry. And just frame this for me. This is in the context. What is your overarching submission here? We're going to these authorities to demonstrate
That the State Immunity Act does not intend to replicate precisely the terms of XC. And as we'll see, it departs in numerous respects from that convention. Not least in section 5, which is strikingly different to Article 11.
because of the presence, the
Presence
absence of
requirement.
presence requirement.
Yes, my lady.
I see. Thank you very much. That's helpful. Thank you.
The next judgment is Ben Carbuche. This is at tab 68. 78. And if the court would turn to paragraph 9, which is on page 1987 of the hard copy pagination, or 894 of the electronic PDF.
Yeah, paragraph.
Paragraph 9, my lady.
Thank you.
Below E, Lord Sumption is discussing both the 1926 Brussels Convention and XE. And he says, starting at E, neither of these conventions sought to codify the law of state immunity or to apply the restrictive doctrine generally. In addition, they've attracted limited international support. The Brussels Convention has attracted 31 ratifications. The Basel Convention, or XE, has to date been ratified by only 8 of the 47 countries of the Council of Europe. Continuing on in paragraph 10, one purpose of the State Immunity Act was to give effect to the Brussels and Basel Conventions and thereby enable the UK to ratify them. It did this in both cases in 1979, but by this time the conventions had been largely superseded by the adoption of the restrictive doctrine of state immunity at common law. as I understand it, that's a reference to judgments such as Trentex and so on in the 70s, by which the court common law developed beyond the position as set out in the 1972 convention.
Yes.
If the court would then turn to paragraph 12 of that judgment, and this is a reference now to the UN convention. Since the passing, if the court would simply read that paragraph, my lady.
Yes.
So again, Lord Sumption stressing that the UN Convention, as we'll come to, is a somewhat limited support or assistance in relation to the 1978 Act. It departs from the terms of the Act. It's has limited support, and indeed the UK has not even ratified it. And so it hasn't come into force at all. Turning to paragraph 31, page 1998 of the hard copy pagination. This is, in my submission, a helpful summary of how to identify a principle of customary international law. I don't ask the court to read the whole paragraph at this stage, but simply to stress the first sentence. Necessary to establish there is a widespread, representative and consistent practice of states on the point in question, which is accepted by them on the footing that it is a legal obligation. And my lady, as I understand it, the appellant does not contend that its construction of section 5 is required by a principle of customary international law. And indeed, it couldn't do so, not least given the diversity of state practice in domestic legislation on that exception, which is evidenced in the handout I've just passed up. Moving on to paragraph 32, then returning to the UN Convention again, Lord Sumption makes clear at the bottom of the page that the Convention hasn't entered into force, therefore it hasn't led to the crystallisation of any CIL rule, any customary international law rule. And Lord Sumption notes at the top of the next page, these difficulties are greatly increased in the case of the UN Convention by the consideration that in the 13 years which have passed since it was adopted and open for signature, it has received so few accessions. And therefore, continuing down below B, it's not to be assumed that every part of the Convention restates customary international law. It's partly based on existing rules of general acceptance and partly aimed at resolving points which are in fact in dispute. And then moving finally in Ben Carbuche to paragraph 39. The important principles identified by Lord Sumption in the second sentence, no one doubts that as a matter of domestic law, Part 1 of the State Immunity Act 1978 is a complete code. It is entirely autonomous in terms of the law of state immunity in this country. If the case does not fall within one of the exceptions, the state is immune. And then moving down to below C, the exceptions are so fundamental in their character, so consistent in their objective, and so broad in their effect, as to amount in reality to a qualification of the principle of immunity itself, rather than a mere collection of special exceptions. And we'll come back to that point in the next judgment I'll take the court to, because it, in my submission, as was held in the next judgment, it means that you do not apply a restrictive approach to the construction of the exceptions. They are not properly understood exceptions as one might think of it as a matter of statutory construction. They are qualifications on the very principle of state immunity, because they are so wide-ranging. And then, if I can take the court to the next judgment and the final one under this heading, which is the London steamship owners case, and that's at tab 85. I'll take the court, if I may, to paragraph 38. Which is at page 2416 in the hard copy bundling, or 1323 in the PDF. And this is a judgment with which my Lord Justice Males will be very familiar because he prepared it together with the members of the court. My Lord, paragraph 38. This is following on from the point I just made. The court states, we should merely record we were not attracted by Mr. Young's argument that a restrictive interpretation should be put on the scope of the definition within subsection 3C, because the structure of the Act was one which provided immunity in section 1, and section 3(1)(a) was an exception, thereby giving rise to a strict interpretation of the exceptions if it was to be removed. We do not accept that the structure of the Act provides any such basis for a restrictive approach to construction of the exception sections for the reasons articulated by Lord Sumption in Ben Carbush at 39. And then moving on to paragraph 39 of this judgment, the relationship between the 1970 Act and public international law, the court observes that the Act falls to be construed against the background of the principles of customary international law. I repeat that section 5 on the appellant's case is not, their construction is not required by an obligation of customary international law, which at that stage drew a distinction between Iuri Imperii and Iuri Gestionis Acts, which was the restrictive theory of immunity. And then focusing on letter F, the Act did not, however, merely seek to frame immunity in terms of this binary distinction, choosing instead to formulate the exceptions to immunity in a series of detailed sections, such that the existence of immunity under public international law is not conclusive as to whether immunity has been removed by the 1978 Act. As Lord Diplock observed in Alcombe at page 600, the fact that the bank account of the Colombian diplomatic mission, which the respondents in that case sought to make the subject of garnishee proceedings, would have been entitled to immunity from attachment under public international law at the date of the passing of the 1978 Act was not sufficient to establish that it enjoyed immunity under the Act. It made it highly unlikely that Parliament intended to require UK courts to act contrary to international law unless the clear language of the statute compelled such a conclusion, but it did not do more than this. And again, I rely on that reasoning in support of my submission that Section 5 is, as a provision that is not ambiguous, should not be qualified or adapted or rewritten to conform with public international law obligations as the appellant advances it. In fact, as we'll come to it, the position under both EXI and the UN Convention is far removed from the outcome which the appellant would wish. And so even if you were to apply certain parts of that convention, you would not get the outcome that the appellant argues for. But that's by the by, because the primary recourse should be to the terms of Section 5. My lady, my lord, the final heading under general principles is the relevance or admissibility of notes on clauses on which the appellant seeks to place reliance. If I could ask the court to turn to the decision of Mr. Justice Sales, as he then was, in the Public and Commercial Services Union case, which is at Bundle 4, tab 61, page 1389 of the hard copy bundle, and page 296 of the PDF. This was a case about interpreting the Superannuation Act 1972 and whether properly construed it required the Secretary of State or the Minister to consult with trade unions before making certain changes to civil servants' benefits. And if the court has the holding at the bottom of that page, 1389, you can see the holding per curiam. Notes on clauses, as distinct from published explanatory notes, are not a proper aid to the interpretation of an Act of Parliament, whether they are circulated to members of Parliament or not. And the reasons for that appear first at paragraph 41 of the judgment, which is at page 1402 or 296 of the PDF.
It's the accessibility point, isn't it?
Yes, my lady. It's contrary to the rule of law and the transparency and accountability of Parliament for the court to have regard to any private or internal or non-public documents in construing an Act of Parliament.
But it's not, I don't think it's paragraph 41. Is my note wrong? What paragraph?
This is a precursor, my lady, to the reasoning. I just introduced this for the court's note. This is the first time, 41 and 42, where Mr. Justice Sales addresses this argument. The defendant sought to rely on, as you can see at paragraph 42, notes on clauses. Mm-hmm. And Mr. Justice Sales says there's no evidence that these notes on clauses were made generally available in the course of parliamentary debates on the bill. It seems they were simply for the private use of ministers in the course of debates. It is not legitimate to refer to them as an aid to construction of the legislation. And the reasons for that are at 53 to 55 of the judgment, page 1406. Mr. Justice Sales looks at the background, what notes and clauses did, and it seems that from about the 1990s, notes on clauses began to be circulated to MPs. We'll come to that and the basis for that date in a minute. Mr. Justice Sales notes at 54 that there are some references in the case law to notes on clauses, but difficult to see what weight was given to them and no detailed discussion as to whether that was appropriate. And then if the court would read paragraph 55 for the reasoning on this point.
Yes.
Moving on then, moving on from this judgment, in terms of the history, my lady, the introduction or the circulation of notes on clauses to MPs from the 1990s, I get that from Benyon, which is at tab 10, bundle 10, tab 141, page 3796 on the hard copy, or 1207 in the PDF.
Sorry, what are we do?
We're looking at Benyon for the point about when notes on clauses began to be distributed to MPs as opposed to used solely or primarily by ministers.
Look that up. What's the date?
1990s. Maybe the court doesn't need to turn it up. I'll give you the page reference. It's bundle 10, tab 140, hard copy 3776, or sorry, wrong reference.
It's tab 141, page 3796 or 1207.
Yes, that's right.
Right, so it began to be distributed in the 1990s.
Yes.
Well, it looks as if they were produced before then, but it's in the early 1990s when they were made available to backbench and opposition members.
Yes, my lord.
Is what it says.
Yes. Clearly, they were used. They were. It seems they were in some use for many decades before, but circulated to ministers for their private use. PCSU is obviously a first instance judgment, but the points of principle are dealt with by high appellate authority. I can perhaps deal with this relatively briefly because Mr. Justice Sales refers to that authority in another judgment on a similar point. That's the case of Bogdanich, which is Bundle 10, tab 140. And if the court would turn to page 3778, hard copy, or 3803 in the 3805 in the is that right? I'm sorry, that's the wrong PDF. The PDF number is actually 1189. So this is paragraphs 12 and 13 of Bogdanich. And this isn't a notes on clauses case, but it's a case in which a minister or the Secretary of State seeks to rely on evidence from a Home Office official as to their understanding of the meaning of the legislation in issue. And so it's an analogous point. And from the middle, really, or halfway down paragraph 13, in construing a legislative instrument such as the commencement order, just as in construing a legislative instrument in the form of an act of parliament, it is a basic constitutional principle that the citizen or person subject to the relevant law should have the means of access to any material which is said to provide an aid to construction of that instrument. It is only material which is in the public domain and of clear potential relevance to the issue of interpretation of a legislative instrument which can be treated as having any bearing on the proper construction of that instrument. And reference is made to the judgment's speeches of Lord Reid, Lord Diplock and Lord Simon in Black Clawson, and further speech of Lord Diplock in Fothergill. And you can see there an extract from Fothergill at the bottom of the page. The need for legal certainty demands that the rules by which a citizen is to be bound should be ascertainable by him, or more realistically by a competent lawyer advising him, by reference to identifiable sources that are publicly accessible. And there, Mr. Justice Sales refers to his earlier judgment in PCSE. So although that related to evidence, the same point applies to notes on clauses. These were not publicly accessible. Indeed, the appellant's lawyers had to attend obtain copies of them in person. There's no evidence that they were available to MPs at the time. They are a purely internal and private document to which the court, in my submission on very high authority, may not have regard in construing the Act. I don't propose to take the court to the Black Clawson and Fothergill extracts, but I will give the court the references, if it would assist, for the court's note. The relevant part of Lord Reid's judgment, cited by Mr. Justice
Are the
Sales.
references not in this paragraph 13?
So Mr. Justice Sales obviously gives the page reference. He doesn't extract the relevant reasoning, and it may assist the court to look at those if the court would wish. And I'll just give those references to the actual judgments. So Lord Reid is at Bundle 2, tab 33, page 370. On the hard copy bundle, referencing or PDF page 32. Lord Diplock, who was dissenting, but this was a point of principle, is obviously the same tab 33, page 395, hard copy, or 57 of the PDF. And Lord Simon, again, same tab, page 402 in the hard copy, or 64 on the PDF. And then finally, in terms of Fothergill, you have the short extract in Mr. Justice Sales' judgment, but for your note, it's Bundle 10, tab 138, page 3708 of the hard copy. And I believe it's let me check the bundling. Yes, it's
I think it's page 1130.
I'm very grateful. My Lord, two final, more recent judgments on this, very briefly, if I may. The first is the Westminster City Council case against NAS, and that appears in Bundle 3, tab 50, page 1033 of the hard copy, or 686 of the PDF. At paragraph 3, Lord Steyne gives some background history. Paragraph 3, brief explanatory memoranda used to be printed at the front of a bill. Such a document was a précis and did not provide background. In addition, ministers were provided with notes on clauses, which did by and large explain what a clause in a bill was meant to do. Later, in an era of greater transparency, notes on clauses were made available to backbenchers. That seems to be the 1990 point. And then moving on to paragraph 6 for the reasoning of Lord Steyne. He's talking here about explanatory notes rather than notes on clauses. Explanatory notes, as your ladyship will be aware, emerged in the late 90s. If exceptionally there's found in explanatory notes a clear assurance by the executive to Parliament about the meaning of a clause or the circumstances in which a power will or will not be used, that assurance may in principle be admitted against the executive in proceedings in which the executive places a contrary contention before the court. This reflects Pepper and Hart. What is impermissible is to treat the wishes and desires of the government about the scope of the statutory language as reflecting the will of Parliament. That applies, my lady, to notes on clauses equally. And then finally, a decision of the court, the Supreme Court, refusing to have regard, again, to private or internal government documents in construing an act. This is the case of INRI Agricultural Sector Wales Bill. This was a reference on a devolution issue to the Supreme Court. And at paragraphs 36, which is Bundle 10, tab 139, page 3769, or 1180 of the PDF, paragraph 36 to 39, Lord Reid and Lord Thomas are again seeking to construe the relevant act. The Attorney General seeks to rely on in aid of interpretation on correspondence between the Wales Office, the Welsh Government and Parliamentary Council prior to the introduction into Parliament of the bill. The correspondence set out views of the Secretary of State and the ministers of the Welsh Government as to the scope of the subject agriculture, whether it should include specific references to legislative competence in respect to the Agricultural Wages Board. This correspondence was never referred to in Parliament. It represented the views of the Welsh Government and the government in Westminster, which were never made public or disclosed to Parliament. In our view, it would be wholly inconsistent with the transparent and open democratic process under which Parliament enacts legislation to take into account matters that are passed in private between two departments of the executive or between the executive of the UK and a devolved executive. We therefore refused in the hearing of the reference to admit the correspondence. We refer to it no further. So, my lady, those are the principles of statutory construction,
Right.
which I wish to raise. I now turn to ground one, my lady. And as stated in the grounds of appeal, this is that the learned judge erred in finding that Section 5 of the SIA 1978 was engaged on the incorrect basis that the acts of computer surveillance took place in the UK, not overseas. My lady, my lords, in order to succeed under this ground, the appellant has to establish that no acts to which these proceedings relate occurred in the UK. We say that submission lacked any reality and is, in the words of the Divisional Court in Levin, artificial. My lady, my lords, you've been taken to the paragraph 41 of the particulars of claim, which sets out a series of acts which plainly took place in the UK. My Lord Justice Mayles pointed to the draining of the battery as one, which clearly occurs in the UK, but in my submission, all of those acts occurred in the UK. That is the geographical nexus for those acts.
So there's not really the draining of the battery that caused the psychiatric injury in this case.
My Lord, it formed a causal role. If the battery couldn't have been used in order to affect the exfiltration of the data, there could not have been any hacking. So it doesn't have to be the sole cause, my Lord, and I don't think the appellant is arguing that any act has to be the sole cause. The court's familiar with concepts under tort law of material contribution as the test for causation. And we submit that so long as it is a material cause of the personal injury, an act in the UK will bring the case within the scope of Section 5. Of course, we don't simply rely on the draining of the battery. We rely on all of those events, those acts, which took place plainly in our submission in the UK. And without those acts, there could have been no claim and there could have been no personal injury. For the court's note, I don't propose to take the court to it, but this is dealt with in the evidence, the means by which the spyware operated, and the best source is in the witness statement of Bill Marzak at paragraphs 12, 18, and 23 to 24, which is in the supplemental bundle, tab 6, pages 22 to 29. And what's clear from that analysis is that although some of the steps involve some positive act by a commander, as my learned friend put it, many of the acts involve acts within the device and within the communications system that connects the device to the UK telecommunications network, and the camera and the microphone that take effect by automatic means, without the commander having to specifically require those events to happen. Now, as I say, the appellant's submission is and has to be that none of those acts took place in the UK, and the sole reason given is that the appellant's officials who engaged in such alleged conduct would, on the respondent's case, on our case, have been located in Bahrain. And so the appellant's case is solely that all of those acts took place where the officials or agents or servants were located. But, my lady, that construction conflates the act and the actor. There is no requirement in the 1978 Act that the actor be present in the UK. There simply has to be an act in this country. And plainly, acts can occur in places different to where an actor is located. A bomb might explode by remote detonation. A time bomb might be deposited and the bomber leave the jurisdiction before the bomb explodes. A remote control vehicle or plane or drone might be operated in this country by a controller who is outside the country. A poisoner might leave poison at a certain location and then depart the jurisdiction before anyone consumes the poison. On the appellant's construction of Section 5, none of those acts would have occurred in the UK. So if a bomber were detonated within the UK by a person located in another country or on a timer, the explosion wouldn't have occurred in the UK. It would have occurred on the appellant's construction in the foreign country where the person who controls the bomb or who left the bomb was located. Similarly, if a drone were flown over the UK by someone based in France or wherever, and then interfered with UK aviation or spied on people or dropped bombs, that act would not have occurred in the UK. It would have occurred where the person operating the drone was located, on the appellant's construction. By the same token, the poisoning would not have occurred in the UK. It would have occurred in the place where the person leaving the poison happened to be at the time that the poison was consumed. My lady, my lords, that is not a tenable construction of the ordinary meaning of the phrase an act in the United Kingdom. Indeed, the respondent's interpretation is supported by EXI and the UN Convention on this point. Both of these contain separate provisions relating to where an act or fact occurs and where the actor is located. Of course, the SIA does not incorporate that second requirement, as we'll come to. But the fact that the drafters of the EXI and the UN Convention considered it necessary to deal separately with the location of the act and the location of the actor confirms that these are two different concepts. And the location of the actor is not coterminous with the location of the act. If I could ask the court to turn now to Article 11 of the EXI. This is at Bundle 1, tab 25, page 178 of the hard copy is Article 11, and also 178 of the PDF. Now, my lady, my lords, you were taken to this text. I don't propose to deal with it at length, but simply to highlight the fact that there are two entirely separate concepts as to where the facts occasioning the injury occurred and where the author of the injury was present. That undermines the appellant's construction of Section 5, which obviously doesn't contain that secondary limb. But, my lady, my lords, you weren't taken to the French text of the EXI, which is of relevance. It's clear from the final paragraph of EXI, the English version, that the French text is equally authoritative. That's set out at page 187.
Sorry, page 187.
187, equally authoritative English and French texts of the Convention. And if we turn to Article 11 in the French text, which is at page 200, un état contractant ne peut invoquer l'immunité de juridiction.
Sorry. What page in what
page? Page 200, my lady.
In PDF.
Both hard copy and.
Yes, thank you.
I'll spare the court my French accent
No,
until.
that French accent's very good.
Oh, I'm grateful. Until the final phrase, which is of importance, my lady.
Yeah.
Un préjudice corporel ou matériel résultat d'un fait, a fact, survenu sur le territoire de l'État du fort et que l'auteur du dommage y était présent au moment où ce fait est survenu. So we see there in the French text, although interestingly not in the English text, this concept which is replicated in Section 5 of a fact. All that's required under the French text is that a fact occur in the forum state. Of course, it also contains the physical presence requirement, but obviously Section 5 doesn't contain that. But that is relevant, and that appears to be what's been adopted by Parliament, albeit changing facts to act.
Sorry, is that not a ground 2 point rather than a ground 1 point?
Well, I'm very grateful. It is. It's while we're on the convention. I thought it better not to return to that.
Thank you.
The reason I'm going to these for the present purposes is because of the physical presence point, which undermines, as I say, the idea that an actor is always present where the act takes place. And then moving on.
Do you rely on use of fact rather than act?
My lord, to an extent that it's relevant. It's difficult to see quite how far it goes, but all that's required is a fact on the ground, and not necessarily an act, albeit I do accept that the indication of the secondary physical presence requirement does obviously qualify that point.
Leaving aside the physical presence of the author, I was just wondering whether the fact that the French text talks about facts sheds any light on what is meant when the English text talks about acts.
Well, my lord, the English text of the convention obviously talks about facts. So they both talk about facts, but the difference derives from the use of the indefinite article. But in my submission, there's little to be attributed to that. An act is different to where, the place of an act, it can be different to the place of an actor in my submission.
Okay.
Just moving on then to the UN Convention very briefly. This is Article 12, the next tab. Page 215 of the PDF and hard copy. And here we have, again, an act. So in this case, we don't have a fact, we have an act. An act or omission which is alleged to be attributable to the state if the act or omission occurred in whole or in part in the territory of that other state. So potentially a more expansive formulation. But for present purposes, the importance being that, again, you have a distinction between where the act occurs and where the actor is located. And the reason for that is they are not coterminous notions, as the appellant would have it. My lord, I'm going to move on now to the case law on the very similarly drafted provision under the old rules of the Supreme Court and now in the CPR on service out of the jurisdiction. Now we accept that this is a slightly different context. It's not state immunity, of course, but as we'll see, the principles underlying the case law on an act within the jurisdiction under the practice direction are similar to those which might apply under the state immunity ground. So just to start with the test itself, I don't ask the court to turn this up, but it's now provided for in practice direction 6b, paragraph 3.19. There is a gateway for service out where a claim in tort is made where, and the relevant provision is, damage which has been or will be sustained results from an act committed or likely to be committed within the jurisdiction. That's very similar terms to Section 5 of the State Immunity Act. Starting with the case of Metal and Rostov, which sets the test for...
In Professor Sarushi made potentially powerful points about it is a completely different regime, isn't it? And there's the added safeguard, the ultimate question, the forum question, the forum non-convenience question, which is always there. Do these cases really help?
In my submission, they do, my lady.
Right.
On that point, the forum question is available to the state. Mm-hmm. The claimants, the forum question is available to the state. The claimants need permission to serve out. Mm-hmm. It was open to Bahrain to seek to set aside service on the ground of forum, and they chose not to do so.
Well, by doing so, they would submit to the jurisdiction.
Well, but it's still open to... What I'm saying is there's no barrier to them. If they fail on state immunity, they can seek to make forum arguments. They haven't reserved those. They haven't indicated they would seek to take those points if state immunity fails. The short submission is that is available to a state.
So the additional safeguard is there. Anyway, all right, you say that we can get some assistance
Yes.
for this case.
Because the principles that underlie the practice direction case law do tally to some extent with the immunity points. And if your ladyship could and the lords could turn to the supplemental authorities bundle, the case of Metal and Rostov, which is at tab 1 of the supplementary bundle. And turn to page 45 of both the PDF and the hard copy numbering. This is Lord Justice Slade referring to the predecessor to the relevant rule under page 45.
Thank you very much. Yes, Metal Rostov.
Yes. Rule 4.2 under Order 5 of the old rules of the Supreme Court, reference to the tests applicable, and then at just above letter H, this is one of the requirements the plaintiff must show. The plaintiff must show a strong probability that the claim falls within the letter and the spirit of the subhead or subheads of Order 11, Rule 1.1 relied upon. This requirement is treated strictly, since if leave is given and if challenge upheld, it will never thereafter be investigated. It is furthermore, turning to the next page, an established principle that a foreigner resident abroad will not lightly be subjected to what is to him a foreign jurisdiction. So, my lord, my lady, it's not on all fours with the immunity test, but the court is very well aware of the obligation to avoid or minimise any exorbitant jurisdiction, and that informs the case law on where an act occurs for the purposes of the practice direction, as we'll come to.
This is no longer English law, is it?
No, my lord, but it's
not strong probability is not the test now. It's a good arguable case about which there's been any number of authorities telling us what it means, but it doesn't mean strong probability.
I accept that, but it's simply a question of underlying where the jurisdiction comes from, what the purpose of the gateway is, and irrespective of whether the threshold test is strong probability or good arguable case, the point is that the court is alert to the need to avoid, if necessary or if appropriate, bringing in a foreign defendant into English court proceedings. I simply rely on these authorities as applications of the simple question of where an act takes place. It doesn't necessarily require extensive consideration of underlying principle to note that a number of judges and courts have held that in circumstances analogous to this, an act has occurred in this country. And the first of those is, as my learned friend took you to yesterday, the case of Ashton. This was a case of hacking. My lord, it's at bundle 4, tab 58.
We finished with Metal and Rostov.
We have.
Is that all you wanted it for?
Bundle 4, tab 58, page 1276 in the hard copy, or 183 on the PDF.
Yes.
And we do rely on the reasoning of Jonathan Hurst, QC, as sitting as a Deputy High Court Judge. Paragraph 62. Ashton's computer server was in London. That is where the confidential and privileged information was stored. The act emanated from Russia, but it was directed at the server in London, and that is where the hacking occurred. He then deals with the issue about where the injury was sustained, which is not relevant for our purposes, but then turning to 63, I also consider that substantial and efficacious acts occurred in London, as well as in Russia. That is where the hacking occurred and access to the server was achieved. This may have been as a result of actions taken in Russia, but they were designed to make things happen in London, and they did so. Effectively, the safe was opened from afar so that its contents could be removed. it would be artificial to say that the acts occurred only in Russia. On the contrary, substantial and effective acts occurred in London. And so we say, in the same way, this doesn't necessarily depend on an examination of the balance of probabilities test. It's simply a straightforward application of very similar words to those that we're concerned with in this case. My lord, my lady, my lord, you were taken to Vidal Hall and Lloyd. Again, these are a lower threshold. These are arguability cases. I don't need or request that the court turns those up. They're referred to in the skeleton, but I do rely on both of them as, again, applying a straightforward and plain construction to the practice direction 6B test, which, as I say, is framed in very similar terms to section 5. So if I could just give the court the references. In Vidal Hall, this is the first instance judgment. It went on appeal, but this issue as to whether acts occurred in the UK, in England, did not. And the relevant paragraphs are paragraph 22, which sets out the nature of the claim, and that's bundle 5, tab 70, page 1717 in hard copy, or 624 in the PDF. And then the reasonings at paragraphs 76 to 78, which is same tab, hard copy, page 1732, PDF 638. And we say it's clear from those paragraphs that Mr. Justice Tugendhat considered that acts of collecting data by a defendant located in Delaware took place in England because that's where the devices were located. And similarly, the reference to the judgment in Lloyd and Google of my Lord Justice Warby is paragraph 47, and that's bundle 6, tab 76, page 1924 in hard copy, or 831 on the PDF. And again, that's an act of collection of data by a defendant located in the US in respect of users in England, and on that case, it was held that it fell within the gateway for acts within this jurisdiction. So, my lord, my lady, my lord, we don't say that the existence of a forum argument in service out cases is a sufficient ground of distinguishing this case law in its entirety. It doesn't argue for a stricter test as to where an act takes place. And as I say, a forum argument is in principle available to the defendant in these proceedings. Just while we're on that point, my learned friend made a similar point about foreign act of state. And I'll just deal with that now, although it's not strictly relevant necessarily to ground one. He made the submission that it's inconceivable or unlikely that Parliament would have enacted a provision on immunity which conflicted with the foreign act of state doctrine. And now, my lady, my lord, there's no authority provided these two principles should be assimilated. Then they're not the same, they're different doctrines, they exist independently. And as my Lord Justice Mayles observed yesterday, foreign act of state doctrine primarily relates to acts within the foreign state's jurisdiction. So it doesn't avail the appellant on this case. In any event, the foreign act of state doctrine is available to the appellant in these proceedings. It can seek to strike out the claim if it wishes on the ground that it conflicts with foreign act of state. And so doesn't need to be bolted on to the immunity principle in circumstances where there's no authority that would justify the two principles being assimilated. My lady, my lord, the final case on relevant judgments, I accept there's nothing on all fours, is the case of Levin, which the court's been taken to. This was an extradition case, as my learned friend explained. I don't propose to deal with this at length. I would, however, just take issue with one point he made on it. And so if the court would turn to the case in Bundle 2, tab 43, page 686, and PDF, page 348. So this is the relevant part of the reasoning of the divisional court on whether an act of hacking of a bank's computer from Russia took place in the US, where the bank's computer was located, and the divisional court held that it did. My learned friend, I think, sought to argue that that finding related to the specific offence of interference with an instrument under Section 8.1 of the Forgery and Counterfeiting Act, I believe was his submission. But, my lady, my lord, that's not where this reasoning appears. This reasoning appears, or starts, at the bottom of page 80 on page 685, when the court is considering offences of theft. You see below page 685, we come to the 4 offences of theft based on the drawings of cheques by Korolkov on the accounts of himself and his wife. Moving on to the next page, clearly evidence before the magistrate from which he concluded that the applicant was an accomplice to the acts of Korolkov, but it was contended he could not be guilty of theft, assuming that Korolkov's actions had been carried out in England. So this is the point about reciprocal or equivalency in the offence in the US and in England. The first ground rested on the assertion that the applicant, in inserting the instructions on the Citibank computer, performed an act of appropriation in St. Petersburg as he sat before his computer and typed in the instructions. He thereby assumed the rights of the bank. That action having occurred in St. Petersburg, the courts of England would have no jurisdiction. And as the court's aware, the court rejected that submission from G downwards. For the reasons we've already indicated, the operation of the keyboard by a computer operator produces a virtually instantaneous result on the magnetic disk of the computer, even though it may be 10,000 miles away. Artificial to regard the act as having been done in one rather than the other place, but in the position of having to choose, we opt for Parsippany, the US, where the bank computer was located. The essence, moving on to page 82, 687 of the hard copy, the essence of what he was doing was done there. Until the instruction is recorded on the disk, there is in fact no appropriation of the rights of Bank Arthur Greyhoe, and we rely on that as well, my lord. The mere act of a Bahraini official allegedly typing into a keyboard, allegedly in Bahrain, a command that the spyware takes certain acts, does not of itself comprise an act on which we could rely. If that typing in of the keyboard was ineffective, if it wasn't transmitted to England, there could be no act causative of personal injury. What's needed is an act in the UK before there can be any acts that would be causative of personal injury. And those acts are all set out in paragraph 41 of our particulars.
Well, is that right? One of the peculiarities of this case is that it's a case of spying, which only causes personal injury because it becomes known to the target, contrary to the obvious intention of the spy. So it seems, if I may say so, artificial to describe the spying as an act that causes personal injury. It's only through the medium of communication later on that it results in personal injury. And looked at another way, all the acts of spying could have taken place somewhere else, and that the injury could have been caused by the claimants being told about it here. So are we really looking at the causative acts here?
My lord, if I may, the first point I would say to that is that the appellant does not argue for an entire tort doctrine.
No.
It doesn't say that the entirety of the tort has to take place in the UK. And he can't say that because that's not what Section 5 says, in contrast to the US case law. So there's no requirement that a complete cause of action occurs in the UK. All that's required is an act causative of personal injury takes place in the UK, and as I've said before, that act doesn't have to be the exclusive cause. Tort law is replete with examples of material contribution. It can't be right that unless there is a sole cause, the obvious example would be a car crash. There are multiple acts which takes place, none of which is the sole cause. And if it's obviously right that all that's required is analysis of whether an act causative in a material way of the personal injury occurs in the UK, not a complete tort. And so we don't simply rely on the spying, we rely on all the acts in the UK which were necessary to enable the spying.
The essence of what was done, which is the phrase used at the top of page 687, is perhaps quite an interesting phrase, because if you ask, well, where is the conduct which is the essence of what was done, the location of the actor doesn't matter. It could be anywhere in the world. I mean, it may be in Bahrain in this case, but it could be a Bahraini embassy somewhere or private premises, anywhere. But what matters is that it's hacking a computer in the United Kingdom.
Yes, my lord. So we rely on that, and in the alternative, we rely on the individual acts, which are components of the hacking, which on any plainly took place in the UK, and were acts causative of the personal injury in the way I've described. My lord, against this, we say compelling authority and indeed logical construction of the act. The appellant seeks to rely on 3 points in support of its position on ground 1.
Just before we go there, and picking up on my Lord Justice Warby's point, do you agree with Professor Sarushi that in section 5, where it refers to an act or omission, that must be an act or omission by the state?
Yes, my lady.
You do?
Yes, it must be implicit. It can't be right that if any act by anyone takes place in the UK, that the state is deprived of immunity. The whole thrust of section 5 is about the state's acts.
Yes, thank you. Sorry, yes, you wanted to address the 3 matters.
Yes, so the first is the ECHR, the European Court of Human Rights judgment in Vida. The second is the terms of the Computer Misuse Act. And the third is the case of your response. Starting with Vida, if I may, the first point is that we gratefully adopt my Lord Justice Warby's observation yesterday that in the circumstances of that case, which involved alleged intrusion on the privacy of 2 individuals by the UK government, it might be thought to be obvious that where the UK government is looking at their data in the UK, that set of facts falls within the jurisdiction for the purposes of Article 1 of the Convention of the UK. It would be an extraordinary outcome in my submission for the Strasbourg court to say, well, although you allegedly intercepted these people's communications and looked at it in the UK, nonetheless, that's outside the jurisdiction of the United Kingdom. We would submit. It's an obvious point which has no bearing on this case. However, there are further points which undermine the appellant's submission on this, reliance on this judgment. The first is that the issue in this appeal simply didn't arise in Vida. The second is, and this is an important one, the case concerned interception of communications by the UK government, of communications passing through the UK. It did not involve the facts of this case by which a state reaches out of its jurisdiction, secretly installs malware into a device located abroad, and then covertly engages the operations of that device and surrounding infrastructure in order to send data out of the device. So it's wholly distinguishable. And the third point is that insofar as Vida is relevant, it actually supports the respondent's case. So if the court would please turn to Vida, which is bundle 9, tab 106, and if the court would start at paragraph 12, which is page 3006 of the hard copy, or 417 of the PDF. Just by way of background, really, paragraph 12, this is how the case came to the Strasbourg court. The applicants, so I believe an Italian and a US national, lodged applications with the IPT using a standard application form. There was, as the court will be well aware, an extensive history of litigation behind this. The applicants alleged that the government had breached Articles 8 or 10 because they had and or continue to intercept, solicit, obtain, process, use, store and or retain their information and communications, and because it was accessible to the government as part of data sets maintained wholly or in part by other governments' intelligence services, and that they might have acted unlawfully under domestic law by taking those various steps. So that's the background. Moving to paragraph 22, page 3008.
Yes.
This is now dealing with the IPT's decision on the point of jurisdiction, on the Article 1 point. The complainants accepted could be determined under Articles 8 or 10, or under Article 8. IPT notice states competence, was primarily territorial. And then the key sentence, therefore, in the IPT's view, a contracting state owed no obligation under Article 8 of the Convention to persons both of whom were situated outside its territory in respect of electronic communications between them which passed through that state. So this is a case about communications passing through the UK and being intercepted by that means. So on UK territory, not the UK exceeding its territorial limits and reaching out to a device. So the IPT held that there was no jurisdiction. Moving on to paragraph 54, page 3020. 431 of the PDF. The applicants, this is now the proceedings before the Strasbourg court. They complain under Articles 10, 8 and 10, but they confirm in the final sentence they no longer wish to pursue complaints relating to material intercepted by foreign counterparts. So the case related solely to material intercepted by the UK, not, as I think had been the case in other examples, where the US provided to the UK government data it had intercepted. So, para 74 now, 3024 of the hard copy, 435 of the PDF. The government did not, so this is the government's case. The interception of communications by the contracting state do not fall within that state's competence, for purpose of Article 1, when the sender or recipient complaining of a breach of their Article 8 rights was outside the territory of the contracting state. So it's an argument solely based on the location of the individual at a relevant time. The government is not making what would have been a very obvious point, namely that communications were intercepted outside its territorial jurisdiction. That would have been, in my submission, a stronger point for it to have made, but it doesn't make that point because it can't, because these were interception of communications passing through the UK. So its sole argument is because the individuals were outside the jurisdiction of the UK or the territory, therefore there's no jurisdiction under Article 1. And that's reiterated at paragraph 77 of the judgment. I don't ask the court necessarily to turn to that. The point is the same. The interference happened to the individual and thus took place where the individual was located in the middle of that paragraph. Then para 81, this is the applicant's arguments, final sentence. In the applicant's submission in 81, where interception, storage, processing, and interrogation of communications was carried out by the contracting state on its own territory. So the interception happened on the state's own territory, reiterating the point from paragraph 22. It falls within the state's jurisdiction. My lord, that's the background, my lady. In terms of the reasoning, it's from paragraph 91 onwards. And they're talking about the Section 8.4 regime, which, as the court will be aware, this is about bulk interception of communications. So it's not targeting an individual device. It's bulk interception of large amounts of communications data, which, as I say, is happening on UK soil. And that's why the court holds at 91, in the context of the Section 8.4 regime, each of the steps which constitute an interference, interception, etc., were carried out by the United Kingdom intelligence agencies acting to the best of the court's knowledge within UK territory. So no suggestion that there's any form of reaching out of the jurisdiction in the way of this case. And the sole argument advanced by the government is rejected. The mere fact that an individual is not in England or the UK doesn't rule out jurisdiction. And at 93, there's some relevant reasoning potentially to our case. Although there are important differences between electronic communications for the purposes of Article 8 of the Convention and possessions, it is nevertheless the case that an interference with an individual's possessions occurs where the possession is interfered with, rather than where the owner is located. Similarly, in the specific context of Article 8, it could not seriously be suggested that the search of a person's home within a contracting state would fall outside that state's territorial jurisdiction if the person were abroad when the state search took place. So the key question is, where does the interference occur? And we rely on the analogy with a house. What's happened in my client's case is effectively, allegedly, the state of Bahrain has reached into their house, has stolen confidential documents located in England, and has secreted them or moved them from that position to the edge of the UK territory. And that's why we say, Milady, you raised the issue yesterday about the novelty of these facts and the extent to which digital changes might bear upon this. But in essence, we submit a simple case. It's equivalent to and analogous with a situation in which, for example, a foreign state enters UK, breaks into someone's house, breaks into a safe, steals the most sensitive and wide-ranging documents and communications held by that individual, leaves the jurisdiction, potentially, or remains in the jurisdiction, and reviews that material. That's effectively what's happened here. Now, on the appellant's construction, if that act of invasion, of surveillance, had occurred as a result of orders from abroad, that act would not have occurred in the UK on my learned friend's submission, or it wouldn't fall within Section 5 because not all of the acts took place in the UK. In particular, the instruction didn't occur in the UK. But in my submission, Parliament could not have intended in 1978, confronted with an example like that, to have required immunity to apply, given that the acts would have taken place in the UK. My lord, moving on to the Computer Misuse Act, I don't ask the court to turn this up. This was perhaps only faintly relied upon by my learned friend, but I will give the court a few points and references. The first point is that the Act was passed 12 years after the 1978 Act on an entirely different subject, and it cannot be a proper aid to the construction of the 1978 Act. Indeed, it deals with criminal liability, which is expressly excluded from the scope of the 1978 Act. In any event, Section 4.1 of the Act, the Computer Misuse Act, makes plain that it is immaterial for the purposes of that Act whether any act occurred in what's called the home country, which means England, Wales, Scotland or Northern Ireland. So that's Section 4.1, Bundle 1, Tab 17, page 121, both hard copy and PDF. So the scheme of the Act is to make the location of the Act, apologies for the repetition irrelevant. And instead, there is a different regime by which factors are considered, such as the location of the computer. And if the computer is located in a home country, then jurisdiction may be engaged. Well, that's consistent with our case on this appeal. But in any event, we submit it doesn't properly bear on the construction of the State Immunity Act. And then finally, moving on to your response, the case on which my learned friend seeks to rely. My Lord, we don't see this really as bearing in any way on the issues in this appeal. This is a case about possessory lien. It has nothing to do with either immunity or indeed where the location at which an act takes place. If I can just ask, well, I won't ask the court to stand up. I'll read out paragraph 11 of the judgment of Lord Justice Morbick, which is at page supplemental bundle tab 3, page 180 of the hard copy and PDF, where Lord Justice Morbick makes clear, in this case, the court is concerned only with the exercise of a common law lien, which in its origin permits a bailey in possession of chattels to refuse to redeliver them to the bailor until he's received payments of outstanding sums due to him. So there's no, certainly no conception by Lord Justice Morbick that this might relate to any other matters. And the question is, was the material in that case possessory or tangible property as opposed to intangible property? And that's the sole ratio of that case. It has no bearing on a location of an act as pleaded and as advanced in this appeal. And then finally, on ground one, my lady, my lord, the appellant did seek to rely in its skeleton on the Interpretation Act, although he didn't, my learned friend didn't repeat that submission yesterday. Section 6.2 of the Interpretation Act provides that unless the contrary intention appears, words in the singular include the plural, and words in the plural include the singular. But, my lady, my lord, that gets the appellant nowhere on this appeal. What the Interpretation Act doesn't say is that words in the singular mean words in the plural. So he can't seek to rely on that to say, well, in reality, Section 5 means acts as opposed to act. It simply means include. It's supplementary. So on our reading, in a case where there is an act in the jurisdiction, the exception to immunity applies, but also in a case where there are acts in the jurisdiction, immunity applies. So to conclude, my lady, my lord, none of the further authorities on which the appellant relies supports its case on whether these proceedings relate to an act in the UK, and there's no proper basis for departing from the ordinary meaning of that word, in accordance with which there are numerous acts in these proceedings within the UK and to which these proceedings relate and which were causative of personal injury. My lady, my lord, moving on to ground 2.
Thank you. Anything else on ground?
And as pleaded, ground 2 is that the learned judge erred in his construction and application of Section 5, which on its true construction requires that each and every act or omission causing injury that forms the basis for liability in the proceedings must occur in the UK. Thus, Section 5 does not apply where the liability in the proceedings for the injury is caused by acts committed partly in the UK and partly outside the UK. Well, my lady, my lord, the first point is that that's inconsistent with the terms of the section, which I won't repeat, and it's striking how much interpolation and reading in the appellant's construction would require. And in my submission, it would essentially require an act of judicial legislation in order to secure the outcome it seeks. The appellant, as we understand it, seeks to rely on 4 points in support of their construction of Section 5 in this context. First, EXI in the UN Convention, and with that, the notes on clauses. Second, HISA. Third, the error that the judge is alleged to have engaged in by considering the consequences of the appellant's construction. And then fourthly, US and, at least in the skeleton, Canadian jurisprudence. My lady, I'll address those in turn. starting with XC, the UN Convention and the notes on clauses. In our submission, there are 5 main problems with the appellant's attempt to rely on these sources. Perhaps I'll outline the 5 headings. First, the State Immunity Act does not incorporate XC, and Parliament has departed from its terms in numerous respects, including in Section 5. Second, in any event, the appellant's construction of Section 5 is itself inconsistent with XC. Third, the UN Convention is not of assistance on its face because of its status and its timing as a material aid to construction. And fourth, and mirroring the point on XC, the construction sought by the appellant is also inconsistent with the UN Convention. And then fifthly, the state practice is notably divergent on the personal immunity exception, such that there is plainly no rule of customary international law which requires the reading advocated by the appellant. My lady and my lord, if I can start with the distinctions between XC and the Act. I've taken the court already to La Générale des Carrières and Ben Carbouche, which make clear that while the State Immunity Act was enacted to give broad effect to the XC, it was not intended to replicate its terms. And indeed, XC was largely superseded by the time of the enactment of the Act. On the specific differences, my Lord Justice Mayles observed yesterday that there were, in respect of, I think, the employment exception under XC and in the Act, and as I understand it, that was accepted by my learned friend. But there are many more, which I will invite the court to look at, a few of them, if I may, starting with Section 3.1a of the Act. This is at Bundle 1, Tab 14, page 94 of the PDF and a hard copy. This is the commercial exception. I'm looking at 3.1a. A state is not immune as respects proceedings relating to a commercial transaction entered into by the state. Any commercial transaction. Now we can see the counterpart in XC at Article 7, which is tab 1, tab 25, page 177 on the PDF and the hard copy.
Is this usefully set out in Professor Sarushi's table?
It may be. I confess I can't recall how. I don't believe that the entirety of the provision is included.
Right, okay.
So Article 7, my lady, at page 177.
Yep.
A contracting state cannot claim immunity from the jurisdiction of a court of another contract state if it has on the territory of the state of the forum an office, agency, or other establishment through which it engages in the same manner as a private person in an industrial, commercial, or financial activity, and the proceedings relate to that activity of the office, agency, or establishment. So there's a territorial nexus in XC which is not present in the Act. And that must be in my submission because of the intervening case law, my lady, and Trentex and so on, which provided for a more expansive, or at least an application of the restrictive doctrine. But there are more distinctions, my lady. I won't go through them all, but they have been adverted to by the Supreme Court in the case of General Dynamics. And this is about service, the service provisions in state cases. So, my lady, if the court would turn to General Dynamics, which is Bundle 7, tab 83. Page 2274 of the hard, page 2274 of the hard copy, and 1181 of the PDF, paragraphs 47 and 48. So Lloyd Jones is considering the respective provisions on service. Of course, General Dynamics was a case about service on a state of process. And he's comparing Article 16, which is the EXI provision, with Section 12. And you can see halfway down, para 47, below C. However, Article 16.2 does not impose any obligation to use the diplomatic channels of the defendant state. This might well be thought inappropriate, for example, in circumstances where the defendant state may wish to avoid service. It should be noted that Section 12.1 SIA, by contrast, makes clear that the channel of communications is to be through the FCDO to the Ministry of Foreign Affairs of the defendant state. And then further, at para 48, a significant difference between the SIA and the EXI is that the latter does not permit measures of execution against the property of the state, except where and to the extent that the state has expressly consented. Moving down. It appears, therefore, that Article 16 is not concerned with proceedings in connection with the enforcement of arbitral awards. By contrast, Section 13 SIA makes express provision for enforcement proceedings against states. There are two very marked further differences between the two sources of law. And as a result of that reasoning, my lady, Lord Lloyd Jones considered at paragraph 76.4, page 2288 or 1195 of the PDF. Court has it, the provisions of the EXI cast little light on the correct reading of Section 12 SIA, because under the EXI, enforcement against the assets of a defendant state is generally prohibited, and the SIA deliberately diverges from the EXI in this regard, in particular in relation to the enforcement of arbitration awards against the state.
Sorry, what paragraph are you reading from there?
76.4, my lord, page 2288.
Subparagraph 4.
Thank you very much.
So we rely on that by parity of reasoning in our case. And my lord, my lady, if it's needed, the distinctions between Section 5 of the Act and Article 12 of EXI have been noted judicially in very straightforward terms. And that's in the case of Heiser, which I'll return to, but just for your lordship and your ladyship's note, I won't ask you to turn it up at this stage, but at paragraph 152 of Mr. Justice Stewart, as he then was, his judgment, he observes, this is for the court's note, bundle 6, tab 79, page 2063, or 970 of the PDF. I am not saying that Section 5 replicates Article 11. It clearly does not. For example, it does not have a presence requirement. As the Lord Chancellor said, the 1978 Act more or less follows the line of the Basel Convention. So, my lady, my lord, that's the first point, that the SIA does not incorporate and in fact departs from, in numerous respects, the EXI. Second point, that the appellant's interpretation of Section 5 is not in any event consistent with the EXI. The appellant, as the court is very well aware, seeks to advance an argument that all acts must take place in the in the forum state in the UK. But as I've shown the court, the French text of the XE simply refers to an act. And it's equally authentic. Use of the singular. There's no suggestion in the text of XE, in fact, that all of the acts have to take place in the forum state. And the physical requirement lim does not override that. The physical requirement lim simply requires that in respect of an act, the author is present. But you can't take from that reading the interpretation which the appellant seeks to derive, which is that there must be an all acts construction. And of course, the appellant doesn't argue that the author has to be present. So the appellant's taking an entirely pick and mix approach to which parts of XE it seeks to incorporate by a process of rewriting into Section 5. The appellant's quite right not to seek that additional lim because it's simply inconsistent with the terms of the provision. But it's another example of how inconsistent and partial the appellant's case is. Third, on the UN Convention, my lady, my Lord Justice Mayles observed yesterday that this postdates the SIA by many years, and we rely on that.
Although in response, Professor Sarushi did say that you can trace it back to earlier international conventions.
Yes, my Lord. Well, I accept that I've made my submissions on the relevant one, which is the XE. I'm talking about in terms of independent life or anything additional. In my submission, it can't of itself assist in the interpretation of the Act, because it postdates it by such a long...
I mean, the reason I asked that, just so it's clear, is that Professor Sarushi relied on the statement by the International Law Commission that the author requirement had been inserted for a particular reason, and it seems to me that that was rather implying that that was something new in the UN Convention, when in fact it was there in the European Convention. So that just got me wondering.
I'm grateful. I gratefully adopt that, my Lord, if I may, and simply reiterate, although the court may well be finding this rather tedious, that of course Section 5 does not contain a physical requirement lim, so any statements from the International Law Commission about what the physical requirement lim means in the UN Convention is irrelevant because it's not contained, and indeed the appellant doesn't seek it, doesn't argue for it in relation to Section 5. So the first point on the UN Convention is the historical one. It postdates the State Immunity Act. Certainly there can be no argument that the Act was seeking to implement the Convention. It's been signed but not ratified by the UK, my Lord, my Lady, and it's not come into force in any event. And these points were noted. I'll give, my Lady, the reference, General Dynamics at paragraph 50, which is Bundle 7. I don't ask the court to turn it up. Bundle 7, tab 83, page 2275. And the PDF is apologies. In the PDF.
Don't worry, I mean, if it's a reference for General Dynamics, I think
1182, my lady.
Paragraph 50 will be enough.
I'm grateful. The fourth point on the reliance on XE and the Convention is, as I've said, and this is a repetitive submission, I'm afraid, but it does need to be made. The interpretation advocated by the appellant of Section 5 is also inconsistent with the UN Convention for very similar reasons. Both the English and French texts of the UN Convention refer to an act in the singular occurring in the forum state. That's inconsistent with the requirement that all acts must occur there. And of course, there's the physical presence point, which the appellant disavows in this case. So, doubly inconsistent and fundamentally inconsistent. And then the fifth point, my lady, is on the diversity of state practice in this area. The court has the handout as to how both the conventions and various jurisdictions address this. The court can simply cast its eye if it would. We're not dealing at the moment with the injury or just the first 3 columns. The court can see that state practice certainly doesn't indicate any domestic approach or uniformity of approach by which all acts must take place in the jurisdiction, or indeed a requirement for a physical presence component. They're differently worded provisions, but nothing that supports any conception of uniformity as to the appellant's construction of Section 5. So those are the 5 points, my lord, my lady, on the conventions. I now have some points on the notes on clauses. And I do make the submission that this should not be admitted, although the court has obviously looked at this de bene esse as an aid to interpretation. It would be contrary to very high principle for this court to have regard to a private document circulated perhaps to a minister, although it's not quite clear.
And I think we've got your submissions on
I've got
that.
my submissions on that, my lady. I'm grateful. I would say, that said, it's, I'll give the court, if I may, well, it's far from clear in my submission that the notes on clauses have the outcome that the appellant would wish, even if it were to be admitted. And I just, without turning them up, refer to certain passages. Page 6 of the notes on clauses, which is Authorities Bundle 1, tab 12, page 68, says that the convention and the act start from premises in appearance strikingly different because of a number of built-in qualifications. The results reached under one or other instrument should not, in many cases, be very far apart. That's far from an invocation of uniformity or identity. Similarly, at page 12 on the notes on clauses, page 74 of the PDF and the hard copy, notes on clauses say that we wish to modify the rules of the convention and apply those rules to both convention and non-convention states. And that's why the convention wasn't incorporated. As the court will be aware, sometimes international treaties are incorporated into acts. That wasn't done here.
Sorry, where is the we wish to modify? It's paragraph 14.
Is it?
Yes. Last few lines of paragraph 14.
Yep.
Yes, my lord, I'm very grateful. Page 74. And then, as far as it goes, I think the court was taken to some commentary on clause, what was originally clause 6 and then became clause 5, the personal injury exception. It's a strikingly, one might think, informal and casual remark that my learned friend took the court to as to the fact that it's difficult to, the reason that the physical presence limb wasn't adopted is because it's difficult to imagine cases in which the author, that was necessary, essentially. But as I think my Lord Justice Warby observed, it's certainly not impossible. One can think of many examples, even in 1978, where, and I've dealt with them, where an author would not be present in the same place as an act. A remotely detonated bomb. This was a time when that might have been an example in the 70s in the UK of some note. And so not only as a matter of principle, but also in its contents, it's submitted that the notes on clauses really give no assistance at all, and what the court must focus on are the words chosen by Parliament in Section 5. My Lord, turning to Heiser,
Yes.
second limb of the appellant's case under ground 2, this is a case which supports the respondent's case in this appeal, not the appellant's. I'm not going to take the court through it in detail. It's a relatively lengthy judgment, but it's important to recognise the circumstances of this case. This was a case in which the claimants were seeking to enforce in the UK judgments obtained in the US, 12 judgments. All bar one of those judgments related to terrorist attacks outside the territory of the US. And so applying section 31 of the Act, the court was required to consider whether correspondingly, if the facts had been corresponding in the UK and England, those would be considered to be acts within the scope of section 5. And the court, entirely unsurprisingly, held that in respect of the 11, they plainly were not acts which would have occurred in England or in the UK if section 5 had applied, because they all occur terrorist attacks outside the US. But one of them did occur within the US. That's the Acosta case. And in respect of that case, the court did not deprive the claim. Well, there were other grounds advanced, but it did not hold that that case would have been outside the scope of section 5. So, my lady, my lord, if I can ask briefly the court's turn to this judgment, which is Bundle 6, tab 79, and starting at paragraph 159, which is page 2066 hard copy or 973 PDF.
Yes.
This is the conclusion of the decision on the 11 non-US cases where Mr. Justice Stewart holds that these could not, on any view, para 159, be held to fall within section 5. And at 160, he makes clear that in coming to that conclusion, he makes no decision on the Composite Act submission. You'll recall that my learned friend took the court to this Composite Act point and arguments that a Composite Act analysis could be applied to section 5, and Mr. Justice Stewart's very clear that he does not decide that point one way or the other. It's a straightforward application of section 5 that the acts occurred outside the US. But para 166, page 2067, the judge deals separately with Acosta. This was a shooting incident in New York carried out by an individual who is not a defendant in the proceedings. District Court held that the defendants were party to a conspiracy to commit the act, claims that incurred damages caused by that conspiracy. Para 167, it is agreed there was an act in the United States for the purposes of section 5. The question is whether it was an act of the defendants. And Mr. Justice Stewart holds that it was. I don't ask the court to turn to that reasoning, but I do ask the court to turn to the conclusion at para 174 on this point.
Yes.
Those reasons, the requirements of section 31(1)(b), so those are the requirement to satisfy section 5 in corresponding circumstances, are satisfied in relation to Acosta, the attack in New York. Now, there's no detailed recitation of the facts in the body of the judgment, but there is in an appendix. So if the court would turn to page 2097 of the hard copy or page 1007 of the PDF, right at the bottom is the account of the facts in Acosta. Shooting incident, 1999, assassination of Rabbi Meir Kahan and shooting of Irvin Franklin and US Postal Police Officer Carlos Acosta in New York. And these are the findings of the US court at para...
Sorry, I've got the wrong page.
I'm sorry.
No, it's my fault. I'm on what page?
We're on
1087?
2098 of the hard copy.
Yes, got it. Okay.
So,
and
assassination in New York of 3 individuals, none of whom is the defendant in the proceedings before Mr. Justice Stewart. The defendants are set out at 10 and 11. One is Iran, and the other is the Iranian intelligence service. And it's said that the Iranian intelligence service acted as a conduit for Iran's provision of support in the form of documents, training, and funding to Sheikh Abdul Rahman and the Islamic group. The Islamic group is alleged to have been involved in the shooting. And then moving down to the next page, my lady, at the bottom of 2099, liability. Right at the bottom, the US court is seeking to analyse the basis on which the defendants were liable. They provided material support and resources to the Islamic group, which completed the killing. And it analyses the elements of civil conspiracy. And right at the bottom, here it has been established by evidence satisfactory to this court that Iran continuously provided material support in the form of inter alia funding, training, and safe haven to the Islamic group so that it may undertake terrorist attacks like the one in this action. Now, my lady, my lord, those would appear, and I put it no higher than that, I wasn't in the case, and my learned friend will correct me if I'm wrong, but those appear to be acts in Iran. Particularly safe haven. Difficult to see how Iran could have provided safe haven to the Islamic group in the US.
Or at any rate, not in the US, that's the point, isn't it?
Outside the US, that's the only point. And my lord, my lady, on the appellant's construction of Section 5, the fact that just one act occurred outside the US by one of the defendants should have accorded them immunity in respect of this killing. It is a causally related, on the US court's own findings, it's a causally relevant act. And because there is a single act outside the jurisdiction of the US on the appellant's own case, that would fall foul of the all acts rule which it seeks to adopt. And that wasn't the conclusion drawn by Mr. Justice Stewart, who held that there was no immunity to Iran for assisting the Islamic group, apparently outside the US, in connection with the killing.
forgive me if I've got this wrong. There wasn't a one-act argument in
No.
Leitha, was there?
No, my lady, there wasn't. But the reason I rely on it is because it puts into stark relief the consequences of the submissions being made by my learned friend. This is an act that occurs on New York soil, a killing of 3 individuals, sponsored, funded, assisted by a foreign state. And even if just one of those acts took place outside the US, on the learned friend's submission, that would accord immunity. My lady, my lord, I move on to the third point relied on by the appellant, which is the consequentialist analysis that it said was impermissible, and the reference to the Litvinenko events and so on. My lady, we submit it was perfectly appropriate for the judge to test the appellant's submissions as to the construction of Section 5 by assessing how they would apply to various sets of facts, and whether the result advocated by the appellant would be productive of absurdity or illogicality, or indeed would be contrary to other international law principles. And my Lord Justice Warby observed yesterday that construction of Section 5 in this case would not only apply to this case, it would apply generally. And so it was appropriate for the judge, we say, to test the construction point by reference to various sets of facts. And that's why we say the judge was correct to advert to the proposition that on the appellant's case, the Russian state would be accorded immunity in respect of the murder of Alexander Litvinenko, notwithstanding that that murder occurred on British soil. That was because at least some of the acts leading up to that murder occurred outside UK soil.
So, well, I think we have the point.
We have that point.
Both of you have engaged, helpfully or otherwise, in
I'm grateful.
testing the construction arguments by reference to hypothetical or actual scenarios.
I'm grateful, lady. I'll move on.
Yes.
But it's a similar point in a sense, because it's the point of principle and whether the consequences for which the appellant argues would be consistent with international law principle. And in my submission, they wouldn't. And I rely for this purpose on paragraph 57 of the jurisdictional immunities case. The court has seen this yesterday. So I don't ask the court to turn it up again. I simply refer, and I believe that my Lord Justice Mayles pointed out that in accordance with that paragraph, which refers both to the principle of immunity and to territorial sovereignty, both are central principles of international law. And just as the exercise of a court's jurisdiction is a departure from the principle of state immunity, so is an act within a forum state's jurisdiction an incursion on its right to territorial sovereignty. And in my submission, it was perfectly proper for the judge to apply that analysis to the results which the appellant's arguments would dictate, which in my submission would result in an unacceptable derogation from this country's territorial sovereignty. My lady, I have heard what your lady said about examples. I don't propose to make expound on any further examples relating to drones or bombs or matters of that nature. I do wish simply to refer perhaps to some more mundane examples, because they also reflect on the appellant's arguments. The appellant's case is that Section 5 is really about car crashes and car repairs. That has no support in the statute, but that appears to be its submission. And so what this is about is a negligent diplomat driving on a street in London and crashing into someone and causing personal injury. And in those circumstances, immunity obviously shouldn't apply. But on the appellant's case, in these proceedings, if the request was made from abroad to that diplomat to go to deliver a document in West London, that would be an act outside the UK which was causally related to the car crash. It was the reason the car journey took place. And on that reading, the car accident would be subject of immunity. I simply make the point, and it's a point about certainty, my lord. My learned friend was saying, well, this will create great uncertainty about the application of the principles. But in my submission, my learned friend's case doesn't eliminate the uncertainty, it simply puts it in a different place. Instead of trying to identify whether particular acts have taken place outside the jurisdiction for the purposes of my construction, you simply have to identify whether any relevant acts have taken place outside the jurisdiction for the purposes of the appellant's construction. It doesn't remove that question at all. You simply have to work out, well, what causally relevant acts did take place outside the jurisdiction and which didn't. So there's no solution to that uncertainty point that my learned friend seeks to advance on his construction. Indeed, I think I took a note of how my learned friend put it. His construction of Section 5 is that all acts causing injury in the legal sense, as opposed to the factual sense, must take place in the UK. Now, I confess not to immediately understanding what that formulation would mean, and indeed how it would be applied in individual cases. And in my submission, it would be just as productive of uncertainty as any other construction. And on this point, we would add that the nature of the tort of harassment does not alter this analysis. I have dealt with this to some extent in response to my Lord Justice Warby's questions, but the fact that harassment is necessarily composed of a course of conduct does not make it a special case for the purposes of this appeal. It is entirely consistent with any other tort or wrong that would be litigated. And that's because, as I've said, the appellant's argument is not about where the elements of the tort occur. It does not argue that all elements of the tort must occur in the UK. It argues that any act causally related must occur in the UK. And it must be the case that in most torts, there will be multiple acts that are relevant to the wrong. I've given an example of a decision to go on a car journey which results in an accident. That's a single act tort, in effect. It's a crash, a claim of negligence, breach of duty of care. But there will be multiple acts in the background that lead up to that. And because of the appellant's construction, the fact that harassment requires multiple acts makes no difference for the purposes of this analysis. You still have to look at multiple acts, whether you're looking at a case of harassment or negligence. So we say, my lady, I do repeat that.
I mean, I think what Professor Sarushi was talking about was when he talked about legal causation. It's I think it's in the context of remoteness. I mean, I'm not sure, speaking entirely for myself, that the direction to go on the car journey, during the course of which the driver negligently crashed, the direction would be causal for the purpose of Section 5.
Well, it might be argued to be a sine qua non.
But that's not the test. That's not the test. The proximate cause of the personal injury or death would be the negligent driving. And I think that's what he was driving at.
I'm grateful. I don't seek to argue the point on that specific example one way or the other. I think arguments would be made that on a but-for analysis, the instruction to go on the journey was a material cause, albeit, of course, questions of remoteness apply. It wasn't tortious, but it was an act that was causative in a sense. Now,
I don't know if it's remoteness, but the fact that the driver was instructed to go on a journey would be completely irrelevant. You drive badly on the English roads, you're liable in negligence if you injure somebody. The fact that you were told to go on a journey by somebody, or that you'd stolen the car, or that you were just going about your ordinary business.
No, I accept in the final analysis in determining liability, it certainly couldn't be a defence, of course. There's no question that a driver would escape liability. I don't place huge weight on this. I'm merely saying that the point about certainty is not answered by my learned friend's argument, because these arguments would be made on his formulation. The court would have to grapple with the question on his construction or mine of whether an act was causative of the personal injury. So on my construction,
Grapple with that anyway.
and you'd have to deal with that anyway. I completely accept that, my lady. But what I'm merely responding to is the argument from my learned friend that his construction resolves the uncertainty. And in my submission, it doesn't, because the court will still be confronted with the question of whether a particular act outside the jurisdiction was properly causative or not. Albeit, he would say, so long as you have one outside the jurisdiction, that's enough. Whereas I would say, well, you just have to have one in the jurisdiction. But that issue applies under both his construction and mine. My lady, my lord, I do repeat in this context the point, and I made it on ground one, but just so the court has it in this context, that these are not new principles, these are not entirely novel sets of facts. And the example of a person breaking into
And you've made that submission very, very clearly.
I'm grateful, my lady.
So I think Canadian and American authorities.
I'm grateful. If I may, just leading on from that point very quickly, and I won't detain the court, we say it's not necessary to adopt the always speaking principle. It's something the court raised yesterday. There's no need to adopt the always speaking principle in this part of the case, because one can simply apply the plain terms of Section 5. But if necessary, we say it would be appropriate for that to be done. applying any relevant knowledge of technological change. And we say, and I'll just give the court some references, News Corps Paras 28 to 30.
Sorry, News Corps.
The case of News Corps Paras 28 to 30 in Bundle 7, tab 88,
Thank you.
page 2525. That's the general principles. And it is a general rule that in most cases, or in generally speaking, always speaking, principles will apply. My learned friend took the court to Lady Arden in General Dynamics at paras 94 to 96, in which her ladyship held that section 12 of SIA wasn't subject to an always speaking interpretation. But just on that point, and very briefly, that wasn't said in relation to section 5. Secondly, that did not form part of the ratio of the case. It was a concurring judgment, but the other two members of the majority did not agree with that part of Lady Arden's reasoning. And indeed, the two dissenting members of the court came to the opposite conclusion. They held that section 12 was subject to an always speaking application, and that's at paragraphs 135 to 137. My lords, finishing then on the US and Canadian case law. We say that the appellant's arguments on this case law are even more ambitious than in respect of its arguments on the conventions. The US courts apply a completely different interpretative approach to their domestic legislation, which is in any event drafted in materially different terms. And in any event, as I think my Lord Justice Mells observed yesterday, the appellant doesn't argue for the entire tort doctrine, which is the analysis adopted by the US courts. So it's difficult to see on what basis it can seek to derive support for its different reading of a different domestic provision. And we say this is another example of the appellant's pick and mix approach to its sources of assistance on construction. Briefly then, I'm aware that my lady has the point that it's a differently formulated statute and differently construed construction principles based on an observation that my lady made yesterday. So I won't deal with this in detail, but if the court would turn first to the FSIA Act, which
Bundle 6.
is at tab 107, Bundle 9, tab 107, page 3037 is the relevant provision. That's 448 of the PDF.
Thank you. Yes.
So it's slightly tortuously crafted, but the relevant subsection is 5, halfway down 3037. Not otherwise encompassed in paragraph 2 above, commercial exception, in which money damages are sought against a foreign state for personal injury or death or damage to or loss of property occurring in the United States and caused by the tortious act or omission of that foreign state. So, firstly, the reference to a tort, and secondly, the use of the definite article, the tortious act, rather than an act. And then, in addition, there is the exception in A and B, the discretionary function exception and further exceptions relating to other causes of action. So it's a strikingly differently formulated provision. The defendant seeks, it's more, in my submission, it's more amenable to an interpretation by which all acts that form part of the tort should occur in the US. The defendant seeks to rely on the Kidane case because that related to the same form of spyware, but that relies on earlier authority from the US courts, which is based on construing or applying statements made to Congress during the passage of the Act. And the first case in which I invite the court to turn is this case of SEDCO. This is an early example at Bundle 9, tab 116, page 3175.
Sorry, tab.
116. And the entire tort discussion appears at 3186, which is page 597 of the PDF. Bottom of the page, 16058A5 is silent with respect to where the non-commercial tort must occur. Okay, so the tort may occur in whole or in part in the United States, and the tort occurs in the United States if the act or omissions directly affect this country. However, the legislative history appears to reject this theory with respect to FSIA. In describing the purpose, the House Committee report accompanying the House bill...
Sorry, I haven't found this.
I'm sorry, my lady.
Page.
The PDF, it's page 597, I believe.
Yes. And where is it? Which
Halfway
paragraph?
down.
Halfway down.
The sentence starting section 16058A5 is silent.
Thank you. Oh, yes, I have it.
It's not very helpfully
No, got it.
reproduced.
Thank you. Yes.
So the court's reasoning really starts in the sentence beginning, in describing the purpose. The House Committee report accompanying the House bill, which became the FSIA, states, it denies immunity as to claims for personal injury or death or for damage to or loss of property caused by the tortious act or omission of a foreign state or its officials or employees acting within the scope of their authority. The tortious act or omission must occur within the jurisdiction of the United States. The primary purpose of this exception is to cover the problem of traffic accidents. This court finds that the tort in whole must occur in the United States.
It looks as though the id that follows the sentence you just read out is a reference to the citation of the House report. So
Yes.
it looks as though that's what the House report said.
Yes. Yes, my lord, I see that. So, really, the entirety of the reasoning here is based on a House Committee report accompanying the House bill. So, a form of legislative construction which might be thought to be either impermissible or at least certainly not a primary form of interpretative technique in this jurisdiction, but forms essentially the basis of the entirety of the entire tort doctrine in the US. This whole tort analysis then proceeds through further judgments. So if the court would turn to tab 118, this is a judgment of Circuit Judge Scalia, as he then was. The analysis of the entire tort doctrine appears at 3220 of the hard copy or 631 of the PDF. If the court has the second paragraph, page 3220, although the statutory provision is susceptible of the interpretation that only the effect of the tortious action need occur here, so it's a point deriving from the differently worded US provision, where Congress intended such a result elsewhere in the FSIA, it said so more explicitly. The legislative history makes clear that for the exception to apply, the tortious act or omission must occur within the jurisdiction of the United States. House report, supra. We recently so held, Persinger. None of these acts were committed, none of the tortious acts, the entirety of the tort was not committed in the US. This is a case about land rights and land that...
So more of the same.
More of the same, my lady. I'll give you the further references without taking
Yes,
the
please.
court to them. The case of Jerez or Jerez, which is at tab 120, page 3248 or 659 of the PDF, similar reasoning on the entire tort doctrine. And then in the Democratic National Committee case, which Malone Friend took the case to, it's bundle 9, tab 123, page 3298, and in the PDF 709. My Lord Justice Mells observed yesterday in respect, I think, of that judgment that there was reference to a statement by I believe, a legal advisor to the State Department saying, well, the FSIA is consistent with the EXI. And we respectfully adopt my Lord Justice Mells' observation that actually, had the legal advisor been informed, or had he known in advance of how the courts would interpret the non-commercial torts exception, he couldn't have properly said that, because even on the appellant's construction, the non-commercial tort in the FSIA is different, in effect, to the Article 11 of the EXI. So just finishing off then, my learned friend seeks to rely on these authorities by referring to two judgments of the English court, the first Al-Adzani and the second Servas, as authority for the proposition that the non-commercial tort exception in FISA is a proper aid construction of Section 5, but in my submission, those statements need to be taken with extreme caution. The point that Lord Justice Stuart Smith is making in Al-Adzani, and I don't ask the court to turn to this, I did take the court to it yesterday under a different head, but for the court's note, it's at bundle 2, tab 41, page 616 and 278 of the PDF. The point that Lord Justice Stuart Smith was observing there is that there is no use cogens exception to Section 1 of...
Sorry, no...
Use cogens, no customary international law exception to Section 1 of the State Immunity Act, which ousts immunity in cases of torture. So it was a general point of high principle, and just as there was no such exception on the face of the US legislation, so there was no such exception on the face of the UK statute. But that's a point about international law, irrespective of the specific terms of the acts, and it doesn't take a learned friend anywhere. The second judgment was that of Lord Clark in Servas, and again, for the court's note, it's paragraph 28, bundle 5, tab 68, page 1641 or 548 of the PDF. And in that judgment, Lord Clark referred to the close relationship between the language in section 13.4 SIA and section 1610A of FSIA. It's nothing to do with section 5 of the State Immunity Act. And indeed, in the US jurisprudence to which Lord Clark refers, paragraph 25, the US judgment he refers expressly to the SIA in construing the US Act. So that's paragraph 25, page bundle 5, tab 68, page 1640, and that's PDF 547. So it's a very different example to what we have in this case. And then finally, my lady, in terms of my submissions as a whole, as well as on this point, we simply add that although my learned friend didn't rely on the Canadian case law orally, he does refer to it underground 2 in his skeleton argument, the case of Kazemi, but again, the construction given to Section 6A of the State Immunity Act in Canada is based on the different terms of that statute, which actually on its face provides for a very expansive form of jurisdiction. And you can see that from paragraphs 68 and 69 of the judgment, which is bundle 10, tab 127, page 3471, and that's PDF 882. So, my lady, to conclude very briefly, we submit that there's no proper support for the appellant's construction underground 2 either, and that instead the court should simply apply the plain terms of the statute as enacted by Parliament. My lady, unless I can assist the court further those
No,
my submission.
Mr. Silverstone, you've covered the ground clearly. We are conscious that you have recently, very recently, been deprived of the offices of your former leader, and conscious that you have had to step into the breach, and you've done so very clearly as Professor Sarushi also made his submissions. So thank you very much indeed.
I'm very grateful, my lady.
Thank you.
And my lady, I believe Professor Webb is to deal
Yes,
with
Professor
ground
Webb
3
next.
and the respondent's notice.
Thank you.
My lady, my lords, the respondent's position on ground 3 is that Mr. Justice Julian Knowles was correct. The appellant seeks to interpret personal injury in Section 5 of the State Immunity Act in a way that is inconsistent with the natural and ordinary meaning of personal injury in English law. And there is no rule of English law or of international law that would permit the narrow interpretation advanced by the appellant, which is that psychiatric injury only falls within Section 5 if it is consequent on physical injury. I have 6 points to make in this regard. First, on the rules of statutory construction, in particular, the always speaking principle as applied to personal injury. Second, that the correct approach was taken to the interpretation of personal injury in Nigeria and Ogbonna and developed by the judge in the court below and then followed in recent cases. Third, even in 1978, when the SIA was concluded, the meaning of personal injury encompassed a standalone psychiatric injury. Fourth, the international law materials do not change or replace the interpretation of personal injury in English law, nor do they create an international concept of personal injury. Fifth, the Canadian law on this point as well is irrelevant. And finally, the policy concern about floodgates, now reframed as predictability, is baseless. So on the first point of statutory construction, it's important first to note that the appellant and the respondents agree that the English courts now define personal injury to include physical and psychiatric injury, and the appellant is arguing that this approach should not be applied to this statute. And this is contrary to the always speaking principle. Now, Professor Sarushi took you to News Corp and HMRC, as Mrs. Silverstone just did. But my learned friend took you to paragraphs 48 and 49, which was dealing with an exception, and I'll come to that. But I just wanted to highlight for you the general principle, which is at paragraph 29. I have it at PDF 2544, and it's tab 88. And that is where it is said that exceptionally, where it is clear,
So this is News Call.
this is News Corps,
Yep.
and I have it at PDF 2544.
Would you like us to look at it?
Just for this sentence, because this is the point that they would have to meet.
Can you remind me which volume it's in?
88.
Tab, that's
Of
tab.
the volume.
Oh, the volume 7.
Very much.
And it's paragraph 29, the part that's at the top of PDF page 2544.
Historical frozen interpretation.
Is that the
Oh, I see.
PDF that you...
Yep, we were there.
Good, very good. So the point is that it is exceptionally that the always speaking principle will not be applied where it is clear from the words used in the light of their context and purpose that the provision is tied to an historic or frozen interpretation. but there is nothing in the wording or the context of Section 5 to suggest that it is tied to a historic or frozen interpretation. And if we could now look at paragraph 33 on the next page, the top of the page, we have the reference to the Crown and Ireland, 1998, where the House of Lords was interpreting the similar phrase, actual bodily harm. And this was a phrase that occurred in an even older statute, the Offences Against Persons Act of 1861. And they interpreted it to include causing or inflicting a recognisable psychiatric illness. On the facts of that case, a neurotic disorder. And as you see from the quote from Lord Steyn there, this was based on the best current scientific appreciation of the link between the body and psychiatric injury. If my lady and my lords could please now turn to paragraphs 48 and 49, which are on PDF page 2549. These were the paragraphs that my learned friend took you to and sought to apply to Section 5 of the State Immunity Act. But the context was completely different. In that case, in News Corps, the always speaking principle was significantly limited for specific reasons. The zero rating provisions had to be interpreted strictly in EU law, and the interpretation was actually constrained by a so-called standstill provision that required the categories of zero rating to be as they existed on the 31st of December 1975. And there's no need to turn to it, but that's set out at paragraphs 21 and 40 of the News Corps judgment. And it was because of those very specific legislative constraints that the court applied the meaning of newspapers as it stood in 1975 and did not include digital editions. This reasoning and legal framework is not transposable to the State Immunity Act. There are rules and exceptions in the Act, but the ordinary principles of statutory interpretation, including the always speaking principle, apply. And there's no need to turn to it, but Mr. Silverstone referred to paragraph 38 of London Steamship, which made this point about the rule and exception being subject to ordinary principles. Mr. Silverstone also took you to general dynamics and how the always speaking principle was dealt with there. There's no need to turn to it. I just refer your ladyship and your lordships to paragraph 94 of Lady Arden's judgment, where she stated that the court can adopt a dynamic construction of legislation, particularly where Parliament uses open-textured expressions which are intended to apply in circumstances that may change in time. Now, in Lady Arden's view, Section 12 was not such an open-textured expression, but that does not exclude the possibility, especially for terms like personal injury or commercial transaction. And the entire content and structure of the State Immunity Act shows that it had no intention of being frozen in time, that this would undermine the objective of having a code of indefinite duration. On the appellant's argument, and my learned friend said that there is no scope for always speaking when dealing with the State Immunity Act. On that approach, then terms like commercial transaction or intellectual property rights or forms of body corporate or separate entity that appear in various sections of the State Immunity Act would be as they stood in 1978, which cannot be right and has not been the approach. The appellant's approach is also contrary to the principle of technical meaning, which was in the respondent's skeleton at paragraph 55 and not addressed yesterday. I'll give the reference.
Sorry, what paragraph to the appellant's skeleton?
It's the respondent's skeleton, paragraph 55. This is Benien paragraph 22.5, there's no need to turn to it, but it makes the point that if a word or phrase has a technical meaning in a certain branch of law, and it is used in a context dealing with that branch, it is to be given that meaning unless the contrary intention appears. And a contrary intention is not to be lightly inferred. So the respondents submit that the meaning of personal injury in English tort law, as it stands today, is part of Section 5. My lady, I see we're nearly
Yes,
at
choose
the
your
lunch
choose
break.
your moment.
This,
if that's
this
a
would be
convenient
a good
moment.
moment, my lady.
Good. Well, we're doing well on time, I think. Article 6. Who's going to? Are you
I will
going
be
to?
addressing
Very
that.
good. And you're on time to finish in good time for
Yes.
Professor Sarushi to have a right of reply.
Comfortably.
To exercise the right of reply, not just have it. Thank you very much. 2 o'clock.
Court rise if able.